If requesters can come back and clarify what they meant, this is going to clog up the courts. I get that. And there's no doubt there's some truth to that. But that's not exactly the whole story of what's happening here. This is something different. This is a request that can be interpreted either way. And when a government body can look at it, and instead of going, I'm a little confused, there's a fact pattern that builds that shows a little bit less than benevolence. The repeated delays, overcharges, suing to withhold information. This is just emails. Just some small thing that they just handed to me handily. Why did they even start litigation to withhold this information? Is it possible that they got back a huge cache of files and reassessed the situation and thought, this could be interpreted either way? Perhaps we can come back and just say, we just saw this as direct communications between Fugit and Travis County DA. Let's ask him for an email address and the proper name or proper spelling of Fugit, even though we absolutely know who this guy is.
In the affidavit, Fugit said the district attorney's office forced him to remove exculpatory evidence from that presentation.
It wasn't just a couple things. It was major chunks of exculpatory evidence that the grand jury deserved to hear.
158 PowerPoint slides reduced to 56.
I did a cause complaint on that request. The one between Fugit and the district attorney's office. There was some odd stuff that happened there. You see, most requests, you have to pay for them, then they do the work. That's typically how it works. Now, there may be some exceptions, like my case, where they got caught doing all the work. And then they gave me a cost estimate, and it was like, well, you did all the work before I even paid for the request. 15 hours of looking through records. 5 hours of compiling PDFs. It's an automated computer program. All it's doing is chugging along compiling PDFs for 1.5 hours. They gave me 26 PDFs through the whole course of this litigation. You think it takes 1.5 hours to compile 26 PDFs? It's plausible, I guess, if they're really large files. These are not large files. Most of them were 1 page, maybe 2 pages. A couple of them were slightly more. In total, what? Maybe 40 pages? PDFs. 2,427 somethings. They call them emails. I got back 2,427 emails. And then, through some wordy word stuff, it went down to 27. They picked some phraseology of words to say, well, we picked these parameters and this and that. We came up to 2,427. And then, in trial, when the judge specifically asked them, did you go searching for these other categories of information? They didn't give a clear answer. And the judge made an inference of, well, you didn't go searching. Okay. It leaves me in a tough spot where, for their first clarification, it took the Travis County District Attorney's Office 12 business days. From clarification to the cost estimate they provided, 12 business days again. Missed the deadline again. Cost estimate to the AG ruling request. It took them 18 business days. They didn't miss the procedural deadline once or twice. They did it at least 3 times. How long do you think it took them from the AG ruling request to come back for them to file the lawsuit first? They have 30 days to file a lawsuit. It took them 30 days to file their lawsuit. That's what started this whole thing. Them filing a lawsuit after all those delays. And what's interesting is, once I came in as an intervener, they were suddenly on time. You know how long it took them from me filing my intervener counterplaintiff filings for them to non-suit their own claims? Did it take them 30 days? Hell, did it even take them 10 business days? 7 business days, if we're counting business days, or 10 regular calendar days. How can you not interpret that any other way than we're slow walking you? Oh crap, he's suing back. Drop the lawsuit, make this go away. Oh, and by the way, we're going to give him files directly. He's represented well, screw those rules. We're just going to talk to the party directly. And when you go to the judge and you say, what are they doing? The judge goes, yeah, they missed their 10-day business deadline. I don't really care. Oh yeah, they missed it twice. Yeah, but I don't really care. Missed a 10-day deadline. Who cares? But when you file, you better be on time. Am I wrong? If I file late, what's going to happen to me? I misses a procedural deadline, and there is TPIA case law on this. You could just do another request. Well, I have news for you. I've done many requests, including the same one I've done litigation for, or very close to it. Just a different time frame. How do you think that request went? You think they were very forthcoming, or like, oh, you finally clarified what you meant. Here it is. You think that's what they did? No. They came up with another reason. They came in front of a judge and they said, we only saw this as direct communications between Fugit and the Travis County District Attorney's Office. There's records that don't quite reflect that, or at least they didn't give me everything, as they so claim. 27 of 2,427 is 1.11% of the big number. Which means that they gave me 1.11% of everything. And they withheld 98.89% of what they found. That's better than the exculpatory evidence taken out of Fugit's slides. I mean, and they're getting better.